Imagine signing a contract under threat or pressure. This scenario is more common than you might think, and it's called coercion in contract law. Understanding coercion is crucial for anyone entering into agreements, as it can render a contract unenforceable and have significant legal implications. Coercion in contract law occurs when threats or harm are used to force someone into an agreement. For a contract to be legally binding, all parties must enter into it willingly. If coercion is involved, the contract is not valid. This applies to both the entire contract and its individual terms. Coercion can take many forms. It might involve physical threats, such as threatening harm if someone doesn't sign. It can also be economic pressure, like threatening severe financial consequences if an agreement isn't accepted. Sometimes coercion is subtle, exploiting a party's vulnerabilities, while other times it's overt and direct. When coercion is discovered in a contract's formation, the agreement is typically rescinded. This means the entire contract is canceled, and both parties are released from their responsibilities. The legal consequences of proven coercion often include nullifying the contract and potentially awarding damages to the coerced party. Proving coercion requires specific evidence, such as communication records or witness testimonies. Courts examine each case individually, considering the extent of coercion and its impact on the agreement. There are defenses against claims of coercion. One such defense is the concept of unclean hands, where one party argues that they can't be held liable for coercion because the other party engaged in similar behavior. However, if both parties coerced each other, the contract would still be canceled, as no coercion can exist in a legal contract. Victims of coercion have several options for legal recourse. They can file a lawsuit to rescind the contract or seek damages. Proving coercion might also lead to punitive damages in severe cases. It's important for victims to document their experience, saving all related communications and noting any witnesses who can support their claims. If you suspect you've been coerced into a contract, it's advisable to consult with a business lawyer. Contract law can be complex, and an attorney can examine the circumstances surrounding the contract's formation to determine if coercion occurred. They can also assist in filing a court case to terminate the contract if necessary. It's worth noting that coercion is just one of several factors that can make a contract unenforceable. Others include undue influence, misrepresentation, and unconscionability. While coercion involves threats or harm, undue influence typically occurs within a relationship of trust. Misrepresentation involves false statements, and unconscionability refers to unfair terms. Understanding coercion and its implications in contract law is essential for protecting your rights and interests. By recognizing the signs of coercion and knowing your legal options, you can ensure that the contracts you enter are fair, valid, and truly represent your free will.